life. There are a lot of misconceptions out there about what that all involves or what you have to do if you have a loved one with special needs that you're planning for. And a lot of times that advice maybe comes from a good place, well-intentioned place, but it doesn't end up helping the person that you're leaving things to or you're trying to benefit. Before I dive in to that, we have a couple of things that you'll get as part of, get after the webinar is over. You'll receive our feedback form, which does give you a place to reach out to us and let us know that you'd like to set up an initial consultation with one of us here at our office. Those initial consultations are complimentary. We schedule them for about 2 hours just to give a lot of time to talk about, talk through your situation, talk about your loved ones and all of that. And then usually at the end of that 2-hour time frame, we can give you a pretty good recommendation of what we would put in place for you. And then you'll also receive a handout on, different types of documents or, I guess, processes that you can go through when you're dealing with a loved one who has maybe special needs or a disability that vary in terms of how restrictive they might be for the person. So the chart is a kind of least to most restrictive option for that individual. And I'll go through some of those today as well in some detail so that you have an idea of what that chart shows you. But and then just as a reminder, our webinar next week is actually on, so same time as this, is on how to minimize stress when you're talking about estate planning with your family and making sure that your family has the least amount of stress possible after you've passed away or during an incapacity as well. So some of the things that you can put in place for that, or just considerations in your plan that you want to think about before you are signing the documents, right? So to the topic today on planning for loved ones with special needs, this can vary from any kind of disability that somebody might have, where they're on some sort of like means tested program, right? Where they have they're not allowed to have more than a certain amount and maintain the benefits that they're receiving. It could be, whether it's an adult or a minor child with special needs that you're trying to plan for, right? The considerations are very similar in some ways between whether it's an adult or a child that you're talking about, but some things are different too, right? It obviously, as that child ages and goes into adulthood, there's going to be decisions you're going to have to make as well. But to start with some of the misconceptions that we run into a lot, or advice that people have told us they've heard about, their child with special needs, is that they, number one, shouldn't leave anything to them, right? That they should just write them out of the will, disinherit them, because they're going to be more harmed by receiving funds than they'll benefit. And this is one of those misconceptions that comes from a good place, a well-intentioned place, right? Where we're talking about, a lot of these children, a lot of these individuals are receiving means-tested assistance, where if they just had money come into their lap, after somebody passed away or somebody gifted them money, they might lose access to the benefits they're receiving. And for these people, especially children with special needs or adults with special needs, the programs are so much more important than just the financial assistance, but also the caregivers they might have access to, or the programs, the social programs they might have access to. Whereas they're particularly harmed by getting kicked off of those benefits, as opposed to somebody who might just be receiving means-tested assistance through like SSI, which they are also financially harmed by that, but it's not necessarily the social and like caregiving aspect that comes into play on that. So this, like I said, comes from a good place. You don't want to leave things directly to somebody who's on means-tested assistance, but that doesn't mean you should disinherit them either. You just need to make sure that they are inheriting in the proper way, so that the way they receive those funds does not cause them to lose their access to benefits and their access to the programs that they're receiving assistance from, right? So disinheriting is a very extreme thing to do to somebody in general, of course, but you're not helping that person at all by not leaving them anything. So you can still benefit them. You just have to make sure it's set up the right way. And I'll talk a little bit about how you would want to do that. Another very common thing, similar to that, but still trying to leave some things for the benefit of that person. Somebody will name somebody else as the beneficiary with the hope that they will use those funds to support that person or to supplement the benefits that they're receiving, right? And that, again, comes from a very good place, but it's not the best way to do things. And there's a couple of reasons for that. When you name somebody as a beneficiary, regardless of your intent for how they use it, if that's all it says, that it goes to this person, well, it's their money, right? You have left it to them. They don't have to use it for the purpose that you've left it, left it for them to use. So you want to make sure that you're putting restrictions on things, you're putting rules in place, not just leaving it to somebody like payable on death on an account with the hopes that they'll use it for the right thing. But whether or not they intend to use it for that person, there's also legal reasons that the person you're leaving funds might not be able to use it for the other individual that you had originally were intending to benefit. Speaking of means tested assistance, right? If somebody's in a nursing home on Medicaid, they're not going to be able to provide those funds to the person you originally intended, because that would be a gift. So leaving it to somebody else, hoping that they'll use it for the individual with special needs, is not a good option, because you're not guaranteed to have the end result that you're looking for. They might not be able to use it for that person. Bankruptcy is another very common situation where somebody can't make gifts, right? That's called a fraudulent conveyance if you're doing that in the middle of a bankruptcy, and you can't gift assets away so that they, follow the original intent of the person drafting the will, or signing the will rather, without causing harm to yourself as the person in bankruptcy. So, leaving it to someone else, hoping they'll use it for that person, whether you hope they will because they're good people and they will follow your wishes, but then you don't know about the unforeseen things that can come up, or because they just choose not to, is not a good option. You want to make sure that whatever your wish is, it's guaranteed to happen, right? You guarantee that it'll go and have to be used for the reasons that you've put in place, not hope that they're used for the right thing. So what you want to do instead when you're talking about leaving assets behind for a loved one with special needs is make sure that if you have them in your will or in a trust, that you're talking about leaving things to them through what's called a supplemental or special needs trust, right? These are trusts for the benefit of the individual that can't be used for the same things that they're receiving benefits for. So like if I was receiving housing assistance, right, for a disability that I had, and I had a supplemental needs trust, that would have to be used for other things than the housing benefit. It could be used for maybe helping me purchase clothes, or, transportation potentially, depending on the benefits. Sometimes, just ancillary needs that I might have that I don't have any funds for because I'm on means tested assistance, but it can't kick me off of my means tested assistance either because it can't be used for that purpose. So a supplemental needs trust is a really great tool when you say, I want to leave this money for this person so that they have benefits, or, that they can maintain those benefits, but also then still receive assistance from me. I can supplement those benefits, can still provide that benefit to them, and they'll still know that I'm thinking and caring about them in that plan. So disinheriting is not the way to go on that. If you want to leave something to somebody, you can do it in a way that doesn't cause harm to them. You just have to talk to somebody who knows how to set up those supplemental needs trusts, knows to ask the right questions about what types of benefits is somebody receiving. Are they on any means tested assistance? And in some cases, maybe they're not receiving means tested assistance, but it's more of the ability to manage finances themselves, right? That might be a different issue. And you might just have them inherit in a way where they're not the ones in charge of it, that somebody else is in charge of it. But rather than leaving it to that person as the beneficiary who's in charge of it, you're naming them as a trustee of just maybe a general needs trust. And so there's a lot of different ways that you can plan for these individuals who, regardless of their needs, their benefits that they're on, you can still benefit them and not cause harm on that side of things. So, special needs trust, supplemental needs trust, these are the same thing, by the way. It's just sometimes they're referred to as one or the other. These are really good tools. And a lot of times people are setting up these supplemental needs trusts either in their will, like as how that person's inheriting, or in their trust as how that person's inheriting. Or sometimes, depending on the situation, they'll already have a standalone separate special needs trust set up for that individual too. This can be beneficial for a couple of reasons on top of just how somebody's inheriting. One, if you want to provide financial assistance to that person now while you're living and they are already on means tested assistance, that's a really good way to do that. Another really useful use, if you will, for this type of standalone special needs trust is this allows your family members or your friends or whomever might want to include your loved one in their plan of how they're going to leave things, when they pass away. It provides them a place to do that so that they don't all have to have separate supplemental needs trusts set up for your loved one, right? They might have one place that they can leave it. So a lot of times when we do those standalone supplemental or special needs trusts, we provide letters that the family can use that say, hey, I'm not asking you or, demanding that you leave anything to my loved one. But if you choose to do so, and you want to think about them in the plan, here's how you want to do that, because this is so that they don't lose those benefits, right? So it's a very useful tool. Standalone special needs trust is a very useful tool when you're also thinking that other people might be leaving assets behind for your loved one as well. It gives it a more, uniform place. You're not dealing with a bunch of different supplemental or special needs trusts. And so informing the family members is a really good thing to do, sending these letters out. We try to write them in a way, for example, that does not sound like you're demanding anybody leave anybody money, just saying, please, if you are thinking of doing this, this is how it would be best for my loved one for you to do that. But when we're talking about how do you plan during lifetime, we're not talking about finances anymore or, how to leave assets to them. But when it comes to how do I help this person in terms of decision making or help them as they age in terms of going from a child to an adult, how do I get that level of decision making so I can continue to be their guardian or I can continue to help them as they go on in life. And that's where that chart of like least to most restrictive is that's what that's talking about, because there are a lot of different options for how a parent who has a child with special needs might step in and help that person, might step in and help continue to guide them on things as they're adults even. So like the least restrictive thing that somebody might do, least restrictive, by the way, in terms of the rights of the individual with special needs. The least restrictive thing that somebody could do is have what we refer to as like disability documents in place, right? So powers of attorney, HIPAA authorizations, living wills in terms of end of life wishes, having that person, if they have the capacity to sign those documents, to put those in place, that grants that decision-making authority to the loved one or that's taking care of them so that they don't need to necessarily go through guardianship. There's also what's called supportive decision-making, which is a little less in effect in terms of like legal authority than a power of attorney might be, but it's less restrictive than a guardianship, for example. So supportive decision-making is, having a plan in place to help the person make decisions without requiring them to have to go through you all the time too. Now, guardianship, even though it is the most restrictive in terms of the rights of the individual, is a perfectly valid tool to use too. I've heard a lot of people talk about guardianship and are like, you never want to do this, it's so restrictive. And it is very restrictive, but the reason it's restrictive is because it's when somebody petitions the court for guardianship over a loved one, they're asking the court to take rights over certain decisions from that person and grant it to the guardian to have the rights over those decisions. So it's truly a shifting of rights from one person to another. That's very restrictive, right? It's very extreme in that term, extreme not in a decision of like doing it or not, but extreme in terms of that's a pretty big decision to make, right? So when you're looking at guardianship for somebody, you just want to make sure it's the right fit. If the person's able to make a lot of decisions for themselves and you can get some of the decision making authority that you would need through a power of attorney or through supportive decision making, maybe guardianship's not necessary. But there are plenty of people who, a guardianship is going to be the right call. So you see this a lot in particular where people have loved ones with special needs. They're going from adult to child, or excuse me, the other way around, children to adulthood, and need those decisions shifted over before they become a legal adult so that as they transition into adulthood, that transition of decision-making authority is much, much smoother for the parent. You see this a lot when the children are, like 17, they're starting to look, the parents are starting to look at petitioning the court for guardianship. And that's perfectly fine if that's what that person needs. Not everybody is going to be benefited by just using a power of attorney, right? Or just using supportive decision-making. The goal should always be, let's do what's best for the person, and try to be as the least restrictive as we can be in terms of that. But sometimes you have to, make the right call for them, regardless of how restrictive that might be. So if somebody's not able or capable of making certain decisions for themselves, and it's just going to be, a big chunk of the decisions they're going to have to make as an adult, guardianship is a perfectly valid tool. Or if somebody has an incapacity, for example, even if they've never had an incapacity before in their life, and like with Alzheimer's or dementia, right? A lot of that discussion is the same for that. If they're able to sign powers of attorney, that's great, but sometimes it doesn't stop them from potentially causing financial harm to themselves, right? As somebody with Alzheimer's spending money, for example. So guardianship is a way to prevent that from happening. But with children with special needs, it's a more gradual transition than from that, that parental kind of relationship continues on even past legal adulthood then. So guardianship is absolutely a valid tool. Nobody should say never do it. It is more restrictive. So you always want to look at all your options, but you don't want to require somebody to, not go through it because you're worried about how restrictive it is, or, require somebody to go through it because that's what somebody told you to do. So always talk with an attorney who, focuses their practice on planning for individuals with special needs, in order to get the best advice on that. And not just from the legal standpoint, but also from the more practical standpoint, right? And that's where that supportive decision-making can really come in. So this side of that discussion of planning for loved ones with or individuals with special needs is definitely more on the, okay, you need to think about these things, especially if you have children with special needs. You need to start thinking about these things more in advance than you might think, right? You don't want to wait until someone's about to turn 18 to start thinking about these things. But it's different than the financial planning side of it or the estate planning side of it in terms of how you leave assets to those individuals, because they come into play at different times and they deal with different sorts of decisions and different concerns. One side of things, planning with like supplemental needs trusts, special needs trusts, is to prevent and maximize the access to benefits for the individual. But then the guardianship or the supportive decision-making discussion is much more about, how do I make sure that they have somebody there now, and while they're still, while I'm still living or while they're still living, that we can have someone step in and help them, not financially, but with certain things that they need to do, like filing taxes maybe, or going to the bank, or signing checks, paying bills, not with your money, but with their money that they might have. So you want to think about both sides of things. It's not just about the money. It's not just about how you're leaving things to these individuals. It's also, what other concerns do you have about, taking care of them or helping them out and guiding them in certain decisions from a more practical standpoint. One thing that I would definitely recommend thinking about too is what happens in terms of that decision-making authority, the guardianship, potentially, if you are no longer able to do it yourself, whether that's because you've passed away or because you're incapacitated, or maybe you're just getting up there in age where you can't quite handle it as much as you used to because of all of the things that are required. So look into who you would want as a backup agent for those sorts of things. When you petition the court for guardianship, you can add on or petition them as well for backup guardians, so that if something were to happen to you, you have somebody in place. So it's very important to think about those things. Nobody wants to think about, well, what happens if I'm unable to do it, especially with a child, right? I mean, that's a hard thing to think about. But it is an important thing to think about, because if you don't have those things in place, it's much more difficult on the individual who needs that assistance at that time if you don't have backup provisions in place. So, and then I'm not seeing any questions. So one thing I'll add again at the end of this is just a reminder to keep an eye out for the things I was talking about being sent out to you. So that feedback form, that does give you a place to reach out to us, set aside time to talk to our attorneys if you're want to plan around a loved one with special needs or estate planning in general, right? And then also keep an eye out for that chart of the decision-making roles that you could play or documents you could use, and the least to most restrictive of them, right? That's just a helpful sort of visual tool on that of, least to most restrictive. And then if you're interested in signing up for our webinar next week, it's the same time. And again, that's on how to minimize stress on family members when you're talking about estate planning. And I don't just mean in the discussions you're having with them, but also when they actually have to step in and deal with somebody's estate. So with that, I will let you guys go. Enjoy the rest of your day and hope to see you next week.